Sí.
Here is the transfer of title, which is the topic that we're going through. So we need to cover title insurance. We need to cover deeds. And then we also need to cover escrow at closing. And then special processes maybe. And then warranty. This one is not too big. Okay. So we're going to start on, let's see, let me go back here. So title insurance. Do you have your book?
Yes.
Okay. So in your book, title insurance, let me get the book. And while I'm getting the book, let me open up that. I think it's title, I'm sorry, Unit 8, right? 708.
7, yeah. It's on 7 here, 103 page.
Okay, 1 second. Actually, let's start with deeds. So the topic of deeds is, I think, Unit 6, yeah. So go back to Unit 6 and remind me, your book is the Modern Real Estate Practice, right? 20th edition?
Yes.
Okay, perfect. So go back to Unit 6. I'm opening up to my presentation so that you can follow along. And I'm getting my book. So we need to go through deeds, which is covered on 80 from 84. So we'll quickly go through from 84.
Okay.
Okay. So on your screen, I'll also be summarizing for you. So on 84, the word title at the top, title to me, I simplify that. If you're going to be writing notes, that's ownership or rights. So when you hear title, it's very different from the car. When we're talking about title with a car, it's a piece of paper, right, that shows you own that car. When it comes to a house, title is what rights or ownership rights do you have to this property. So title is the same thing as rights or ownership to that property.
But it's not a paper, a piece of paper.
The piece of paper is the deed, which is what we're going to go through. The piece of paper that shows you got this property from the seller is the deed.
Okay.
Okay. So this rights that you have to this property, the rights that you have to that property can be transferred 2 ways. One way is where you see voluntary alienation. All voluntary alienation means is voluntary means that I am doing it, so I have the power to do so. It's by choice. So while I'm still alive or when I die, it's in my will, and I say who's going to get the property. So voluntary alienation, as you can see, is during my lifetime, I'm transferring the rights of this property from myself to someone else, either by selling it to them or giving it as a gift, or when I die, I put it on my will and I say my child is going to get the property.
Okay.
Now, the paper that I use to transfer my rights to someone else is the deed, which is what you're seeing on the 4th paragraph. You're seeing deed is in bold. So deed is a document in which I will transfer my rights to someone else. That's a piece of paper.
Okay.
The person who is transferring their rights on a property is known as a grantor. So where you see grantor or grantor, that's the person transferring. Normally in a real estate transaction, grantor is the seller, and then grantee is the buyer.
What is the difference about the grantor and the divisor? I got a little confused.
Okay, so divisor is in a will. So
Okay.
divisor is where I have a will and I'm saying my daughter Angela is going to get this property when I die. So in a will, if you've ever done a will, or if you have seen a will normally have everything that you own. Everything that you own could be a car, it could be money in the bank account, it could be jewelry, it could be clothes, it could be whatever. Included in the will is, again, everything that you own, which is also property. So your house in the will is known as device. And then all the other personal property, the money in your bank account, the car, the jewelry, the stock, the bonds, the clothes, all that is known as legacy.
Okay.
So in a will, my mother could say that Brenda gets the house. In a will, my mother could say my sister Sheila gets the car. So I, the person getting the house, will be the devisee, as you're seeing on figure 6.1.
Okay,
So anytime you see device or legacy, both of them are in a will. Device is the house. Legacy is personal property.
Okay.
Okay.
And
then in a
like
deed, go ahead.
It's going to be, when say like the word grantor is going to be always a sale.
Well, not always, but normally, yes. Because again, if we review back, your mother could decide to give you her house as a gift, right? So let's say you're getting married and your parents are going to give you a house. They're not selling it to you, but they're giving it to you as a gift. When they give you that property on the deed, the piece of paper, your parents are the grantors and you're the grantee. So yes, 80% of the time it's the seller is a grantor, but don't stick to that. All grantor means is who's given the property, whether they're giving it as a gift or they're giving it in exchange for money. That's the grantor.
Okay.
Okay. And then we get into this piece of paper, the deed. What do we need in order for us to say it is a good transfer and it is legal? That's where you have your bullet points. So it goes into the grantor has legal competency. Legal competency just means that they are of age, they're over 18. And they have sound mind, which is they know what they're doing. And then you get to page 85. You have the grantee named. Who's getting this property? We need to know who is exactly getting the property. So it cannot say, I give this property to my brother. It needs to say, I give this property to my brother, David Charles. It needs to name who's getting the property. And then it goes into how much are you giving up this property for? Sometimes it's money. Sometimes it's because of love. Your parents giving you a property because they love you. They're not going to charge you money. but that's still consideration. And then the granting clause, what are you getting with the property? Does the property come with restrictions? Does the property come with homeowners association with rules? What are you getting with the property? That's a granting clause. And then habendum clause just says to have and to hold. What do you actually get? So granting clause is what are you getting? Habendum clause is what did you get? And then the rest, I think you're good. It describes the property, where the property starts, how far it goes. It talks about any restrictions or any rules that exist. And then the last two are key. Acknowledgement is the seller's signature. Acknowledgement is not saying, yes, I got it, but acknowledgement is the seller's signature. And then the last one, delivery of the deed. That's where you received the deed. It doesn't, so here I normally tell people in class, it does not have to be recorded. So what does that mean? You're getting married, your parents are giving you the property. They don't have to go to county records to record that they gave you the property. As long as it is delivered and accepted by you, you own it. Okay. So that's part of the deed. Let's skip to types of deeds because that's all tied together. So you're going to page 88 unless you have a question.
No, I'm good, thank you.
Okay. So 88 is talking about the types of deeds with the bullet points. I'm just going to summarize them through the bullet points that you're seeing on 88. A general warranty deed, seller has 5 promises. A general warranty deed is what you see on page 89. On the left-hand side, there are bullet points. Seller has 5 promises. So by that we mean if any of these things that the seller promised are not fulfilled, you take the seller to court and the seller has to fix it. So that's why general warranty deed has the best protection for the seller, for the buyer, because the seller has to make sure that they are good with all these 5 promises. Special, and I remember general warranty deed, 5 promises, 5. So the way I'm told in the military, because again, I was not born here, so this is stuff that I'm told how the military works. There are very few people in the military that have the 5-star. So I guess you get a star because of something that you did while you're in the military. So I think there are only 3 people in the U.S. that have the 5-star general, which is the highest level in the military. So 5-star general, best protection for the buyer.
Okay. That's good for remembering.
So 5-star general, best protection for the buyer, because that's the highest you can get. Special only has 2 promises. Special only has 2 promises. So when I look at the word special, this one, I remember going to the store or going online, and anytime I remember there's a special, I think of a sale. So buy 1, get 1 free. So you're getting 2 things. It's a special. So you're only getting 2 things from the seller. Seller is saying, number 1, I own this property. So what does that mean? I have the right to sell it to you. if I forged my husband's signature and later on we find that I did that, then the seller has to fix it. So grantor received title. I own this property. I have the right to sell it to you. Next coverage from the seller says, these are the people that I owe money and these are the people I have paid, but I'm only responsible for the time that I owned this property. So let me give a little bit meat to it. I bought my house in 2006. So when I'm selling my house, if I'm using this deed, then I'm going to say since 2006, these are the people that I owe money, and I'm only responsible from 2006 till now. Anything before 2006, I'm not covering you for that because I didn't own the property. That's a special warranty deed.
Okay.
Okay. The next one, bargain and sale. So that one, I usually look at the word to bargain. Anytime I see to bargain, we are trying to negotiate something. So with a bargain and sale deed, this one, there are no promises whatsoever. No promises whatsoever. So this one also, the way I remember this from a student is the initial B for bargain and then the initial S for sale. So this is a BS. You're getting nothing. You're really getting no coverage from the seller. When would I be getting this type of a deed? When I'm buying a property that is maybe through a tax sale. You didn't pay your taxes. Baltimore County or Baltimore City gets, wherever you live, they take the property and they auction it as a tax sale. When the Baltimore County is selling my property, you, the buyer, cannot go after Baltimore County if you find something wrong with the property. So that's why it's a BS, bargain and sale. Okay?
Okay.
Last one, which is on page 90, quit claim. Quit claim, so quit, you're saying I'm done. So quit claim basically has no coverage whatsoever either. So this one says provides the least protection to the buyer. What's a good example of when we use this one? This one is when you're going through a divorce, you're buying him out, so you're paying him his half share. You now get the property, so you use a quit claim to show that you now own the property. So that's a quit claim. There's no guarantees, nothing. You good?
Yeah.
Okay. Page 91, reconveyance. So reconveyance deed is the one that says, so reconvey, to me, anytime I have the word, the two letters R and an E, I think of reverse, so like I'm going back. So reconveyance deed is where it goes back to the person who gave it to you. So reconveyance deed is from the trustee to return the title back to the trustor. So reconveyance, it goes back to the person that created it. Here, don't dig deeper in terms of an example. Here, the simplest way you can look at this one is reconveyance. You put in your car in reverse, it's going back. That's all.
Uh-huh.
It's going back.
Okay.
And the difference between reconveyance and trustee's deed, reconveyance reverse, it's going back. Trustee's deed, you're going forward, but it's going to a different person. it's going to a different person. So if you look on the left-hand side where you have the lines, those help a little bit. But if I'm going to simplify it, reconveyance, reverse, it's going back to the person. Trustee's deed, it's going to a different person.
Okay, example of reconveyance, like what should be an example?
Honestly, don't dig deeper on that one. Reconveyance,
Okay.
it could be that, I'm going to use myself. My mom is not feeling well. She starts saying that she's going to be giving me the property. I don't know, she got coronavirus, so now she's thinking that she's going to die, so she starts saying that I'm going to get the property. But then she gets medicine, she feels better, so now we reconvey it back. I'm just simplifying it.
Okay. Thank you.
Yeah. Okay. Anytime you transfer property, then there's going to be transfer taxes, so that's where some math comes in. So we're going to skip that and go to the next way you can transfer the right to a property is on page 92 at the bottom. So I'm looking at what we've covered. The purpose of a deed. Okay, types of deed we've covered. We've covered elements of a deed, and then we'll talk about recording. Okay. So involuntary alienation. So this is not by choice. Someone else is doing this for me. I simplify this by looking at page 93. Look at the second column. The 4 ways how my property is able to be transferred without me having a choice is through a sheet, condemnation, foreclosure, and adverse possession. So we'll start with the first one. A sheet is you died, you don't have a will. Oh, I didn't mean to do that. You died, you don't have a will, you don't have anyone related to you at all. No one in the world is related to you. So now the property is transferred to the government. That's a sheet. So no will, no one related to you, it goes to the government. Condemnation is where the government has said, we want to use this space for public purposes. So this is where they're saying, we want to build a road, or the road has to become wider, or we have to put a park, we have to put a school, we have to put a stadium, whatever it is. And whatever that space is requires them to take your property. That's condemnation. You don't have a choice. So condemnation here, if I'm going to review, condemnation is how they go about it. Why they do it is eminent domain. So the difference there, eminent domain is the right for the government to take personal property. How they do it, the process, is condemnation. Are you okay with that?
Yeah, I think this part I'm okay with, like foreclose, adverse possession.
Okay, so you're good with adverse possession, what it means?
Yeah, when
Okay.
when you live to the property more than 20 years or something like that, and then you have the right to get the property or the piece of land.
Good, good. Okay, we're good with that. So I'm just looking at the notes. Okay, and you're good with what probate is?
Probate, I would review probate.
Okay, so probate is where somebody passed away and the property needs to be transferred. So if I were to pass away today, my property is automatically going to be owned by my husband. He lives in the property. If he dies, so now both of us have died, then now my daughter owns the property. Let's assume she's 12 right now. Let's assume she's only 16 years old and both of her parents have now passed away. She owns the property. She can continue living here. Nobody can kick her out. She can continue living here for however long she wants, as long as she's able to pay and take care of herself, that's fine. We can assign a guardian in our will who's going to take care of her. The day when she decides to sell the property, then she needs to go through probate.
Okay.
The probate is a legal way for somebody who gets a property because somebody died, and now they want to sell the property. That's probate.
Okay. Good. I didn't know that part.
So now we need to go to the next chapter, which is title records. So title records is going to cover where the question is asking importance of recording, and then we'll talk about title insurance in this chapter as well. So public records. The reason why you want to put the documents in public records is for you to get two things. You get notice, and I know it's not displayed well in your book, but notice is presented in bold, and then skip to page 105, you see priority. So recording does two things, notice and priority. Recording does two things, notice and priority. Let's talk about what notice is. Why would you want things to be recorded? If you're talking about notice, notice is what? I want people to know. So when it comes to recording, so I'm going to put it on the screen as well for you to see it. So recording does two things. Gives notice and establishes priority. That's the reason why you put documents in recording. I'm sorry, why you record documents in public records. So let's talk about notice. There are two types of notices which we went through. Constructive notice just means it's in public records. For example, it's in Google. If you want to do your research, you will find the information. Actual notice is now I know. I now know Brenda owns this property. Priority is having to do with money. So for example, you can go out there, buy a house cash. Then you're going to put it in public records so that people know that you own the property, but you don't have to. You bought it by cash, so you own the property. You don't have to put it in public records. Let's give another example. You got a divorce. You now own the property. You get married to another person, but you don't want them to know that you own this house. So you don't put it in public records. There's so many reasons why people don't put it in public records, because they don't want the world to know that they own the property. Priority.
There's no obligation for it.
No, the only time you will need to record it is, again, if it's tied to money. That's why I tried to separate the two. If you buy it in cash, it's up to you whether you want to put it in public records or not. You're still going to pay the transfer taxes, don't get me wrong. You're still going to pay the government for buying this property, but recording is your choice, especially when you buy the property cash. You don't have to. Or you got divorced, you bought each other out, you don't want your second husband or wife to know that you own this property, so you don't have to record it.
Okay.
Priority has to do with money. So if you're borrowing money from the bank, well, yes, they do want it to be recorded. So priority is where when the property is being sold, they're going to look at who got here first. So priority is where they're going to go through, sorry, I'm skipping through. Priority is where they're going to go through the public records and see, okay, who got here first? That's who's going to get paid first. It has nothing to do with the amount of money. It's when it got recorded. So that's why on page 105, if you look at priority, it says, refers to the order in which documents or liens were recorded. Nothing to do with the amount, it's who got there first. So if you bought a house today for $300,000 and you also borrowed $10,000 today to fix the house, and the $10,000 lender went and recorded the information, when you're selling the house, who's going to get paid off first is going to be the $10,000 and then the $300,000. It has nothing to do with the amount, it's who got there first. Always under unrecorded documents, always the government is going to get paid first. So you'll have to pay your taxes and any of the things that you owe the government. They have to get paid first, but they're never recorded. Are you good with the understanding of what chain of title, title search, abstract of title for the next 2 pages?
I would like to review the abstracted title.
Okay. So abstract of title is a report I get. So if I go back, chain of title is I'm tracing back who owns this property from Sarah, the current owner, all the way back to 60 years or even longer. So now that I've done my research, I will produce a report. It's like you doing your, I don't know, when you go to college, you're doing your research and then you write a paper. Abstract is that piece of paper where you're presenting your research. So abstract is where I'm showing Sarah owns 5213 Washington Avenue. She bought it on June the 1st, 2018. She bought it from Brenda Kasuva, and Brenda Kasuva bought it from Rachel in 2017. So that's an abstract. Abstract is a report, the summary report.
Okay.
Marketable title is what you're showing the buyer that shows this property doesn't have any issues with it. So marketable title is where you're saying all the rights that you own on this property, you're transferring it to the new owner. No one can come in the future and say they own this property. That's a marketable title.
Okay.
And then we finish with something that we started off with the questions, proof of ownership. So here I'm going to read a couple of sentences. Proof of ownership is evidence that title is marketable. So proof of ownership here is just showing marketable title, evidence of marketable title. The deed itself is just a piece of paper to transfer property from one person to another. It's not proof. So then this is where we review certificate of title. It's not really a guarantee because, again, a certificate of title, like you see it in italics, it's not a guarantee of ownership. All a certificate of title is a report from public records showing who has owned the property. That's it. So if something was never recorded, then how would we know? So it can't be a guarantee because if it wasn't recorded, we can't know.
But did you see on the page 107, like They say a certificate of title, title insurance, or torrent certificate is commonly used to prove ownership. That's why I got confused on that part.
Yeah, but again, go back again to where it says proof of ownership. Proof of ownership is evidence that title is marketable.
Okay.
So proof of ownership is just saying, I have a good title. I have all these rights are good. I'm transferring them to you. It's not proving that I own this house. Two different things. That's where people get confused. Proof of ownership is just saying my title is marketable. And if you go up to the top on page 107, what is marketable title? Bullet points. There are no defects. There's no doubt that all these rights are good. No one in the future can come and claim they own the property. And in the future, you shouldn't have issues when you're selling the house. And I know it's wording, but proof of ownership is marketable title. How do you prove you have marketable title? That's all. Are we good with title insurance?
Yeah.
Okay. So we have the two types of title insurance when it's bought, and then let me go back to, so we have about 10 minutes. Let's see, what are we missing? So we covered deed, we've covered title insurance. So now probably the next thing is to cover, if you're looking on your screen, is covering a little bit about closing. So it's talking about escrow, closing, transferring the property. So that goes into the closing chapter, which should be, I think, 10, 12, somewhere around there. No, it's past 12. No, closing is where, yeah, unit 14, which is page 255. So we need to get comfortable with closing statements as it's shown on here, responsibility of the escrow agent. So the reason why this ties together is because at closing, if you're selling your house or if you're, again, giving it to someone, then they have to transfer the rights from one person to another, and that's done at closing. So a couple things that we're going to highlight here is going to be, I'm not skimming over it, but on page 258, just review that because that's going to review what we just covered in the two chapters. So title evidence, if you want a good summary again, read that part. Okay? But here, let me bring your attention to one thing. Page 260. When you get to closing, IRS, so where you see Internal Revenue Service, IRS is going to ask for that form 1099-S to show the seller's social security number, so that they know whether they need to charge the seller, what is it called? Capital gains. So here, the big one here you're noting is the 1099-S. Then you see conducting of closing. So there are two types of closing. You have the face-to-face closing, which is shown on page 261. And then you have the closing in escrow, page 262. The difference is closing in escrow, we don't do it in Maryland. So all that means is you and the seller never meet, you never get to exchange the keys, everything is done by a third party, and that's a closing agent, the escrow agent. If you're borrowing money from the bank, then we need to talk about the laws that you see printed on page 263. They're all in bold. There's RESPA, MDIA, and TRID. When it comes to the first one for RESPA, so let me know if I'm covering stuff you already know. Sorry.
Okay, later.
Okay, so RESPA at the bottom, you need to pay attention to those 3 bullet points. So RESPA section 8 says no kickbacks. So what does that mean? If I'm friends with the title company and you use that title company, the title company cannot give me a referral fee or a kickback. That's not allowed in real estate. Section 9, seller cannot say which title company you have to use. And then section 10, lender, bank, since you're collecting the taxes and insurance, homeowner's insurance, as part of my monthly payment, you cannot collect upfront too much. So make sure you review those 3.
Okay.
And then page 264 introduces the next law, TILA, at the very bottom. TILA RESPA Integrated Disclosure Rule, so that's TRID. What you need to know about this one is that there are 2 forms, and the forms are shown to you on page 265. You have the loan estimate and the closing disclosure. The loan estimate, like it sounds, this is where the lender is giving you an idea as to how much it's going to cost to borrow money from them. 3 things you need to pay attention on this one. First is, when do I get this document? Excuse me. On the 3rd sentence, so I'm on page 265, sentence number 4, sentence number 4. The loan estimate form must be provided to the consumer 3 business days after loan application. You need to remember that. So this is where you're buying a house, you're borrowing money from Bank of America, you put in an application, Bank of America gives you an idea how much it's going to cost to buy this house. They have to give you that form 3 business days after you apply. The second thing you need to know is on the 2nd paragraph, the only money they can collect up front is for the credit report. So 2nd paragraph, the 1st sentence, the only fee the lender may collect is the fee for the credit report. And the 3rd thing you need to know about the loan estimate is where you're seeing the bullet point. So Bank of America has given you an idea as to how much the costs are going to be. The costs are grouped into 3. No tolerance means these fees cannot change whatsoever from today, and from today till the day that you get the keys to the house. The next set of costs cannot change more than 10% if you're using the bank's partners. So if you're going with Bank of America and Bank of America says this is the title company we use, and you use their title company, those fees cannot change more than 10%. And the last one, there are certain things that the lender does not have control as to how much they charge. For example, your homeowner's insurance, whether you go with Geico, State Farm, Progressive, they're all going to charge different fees. The other form that is required by the government to be given to you is a closing disclosure. So that's at the bottom of page 265. And the closing disclosure also needs to be given to the buyer within a certain time frame. And that time frame is within 3 business days of closing. You will see that in sentence number 1, 2, 3, 4, 5. So sentence number 5 reads, the buyer must receive a completed closing disclosure at least 3 business days before the closing. And then the next sentence might be useful. If your interest rate has changed more than 0.15%, you cannot close. You have to get new documents and wait 3 days. Okay, finishing up, go to page 275. Finish up.
Yes.
Okay. Are you good with debits and credits?
Yeah.
Okay. So then you know what is owed and what is paid at closing, and then prorating. So skip to page 278 then. Review this again if you don't know already. So prorating just means what? There are certain things that are paid on a certain date, and that due date does not change just because I bought the house. So for example, in Maryland, taxes are paid either you pay it July 1st, the entire bill for the year, so from July 1st to June the 30th, or you split it into 2. Half of it is paid July 1st, the other half is paid in January. So when you buy the house today, May the 23rd, seller has already paid taxes for January, February, March, April, May, and June. So prorating will mean what? I will need to credit back the seller from today, May the 23rd, to June the 30th. So that's prorating. You're not paying the entire amount. You're just paying the part that you owe.
Oh, okay.
So are you good with these bullet points for prorating?
Yeah, I think so.
Okay.
I'm not good in the math part of that, but...
No, we're not doing the math at all. Yeah, so here we're just talking about if you're going to be doing the math, you need to remember certain things. Seller owes the day of the closing. So if settlement is today, May the 23rd, then seller owes till May the 23rd. Whether you get the keys today at 6 o'clock in the morning or you get the keys today at 9 o'clock at night, seller owes whatever needs to be calculated till closing.
Okay, yeah.
Yeah, I think that's it when it comes to this topic. The other one that I see maybe you would have one question is on foreclosure and short sale. So do you know what a short sale is? Do you understand what short sale is?
Short sale is the one like when the bank gets it? No, I don't remember short sale. Foreclose is the bank, right?
Right. So foreclosure is where I didn't pay my mortgage or I did something that is going against the rules of the bank and the bank takes the property. That's foreclosure. Short sale is where I bought the house when the prices were high. So let's assume you bought the house in 2006 for $285,000. In 2006, the house was worth $285,000. Today, that house is only worth $200,000. So now when you're selling it, you're going to be short about what? $80,000. Because you can only sell your house today for $200,000. You're not able to sell it for $285,000 or more because you bought it at a different market. That's a short sale. The bank has to forgive that $80,000 that they're not going to get. That's a short sale.